Blevins. I'm here on behalf of the Texas Trial Lawyers Association, and we are opposed to the bill. We are passing out information that includes our analysis of the bill provisions, excerpts from Judge Davidson's testimony before the House Committee. Judge Davidson is the judge in charge of the asbestos MDL, which would be directly affected by this bill. Also his ruling on responsible third parties, which is relevant to the third part of the bill, which no one's addressed yet. And then two articles that specifically refute and undermine the findings in the Garlock case, which you heard about earlier. That case is a lower bankruptcy court opinion. It has already come under intense fire and criticism and has yet to be appealed. So I don't know that it's appropriate to consider significant legislative reform based solely on that one opinion. And then finally, asbestos bankruptcy trust form as an example, which sets out the fact that asbestos bankruptcy trusts are capable of defending themselves through an audit process in which all of this information that's developed in the tort system is compared against those very same bankruptcy trust claim forms. And so this concern that there's one piece of evidence that's going to be one place or another, the trust audits would flesh that out, and they have severe penalty abilities if that came under fire. I'd like to address for just a minute the four areas of the bill. The first, as Ms. Andrews testified to, is really just restating what Judge Davidson already requires under the current case management order and the standard discovery. The second is actually a much more unfair practice in the sense that it would force the plaintiff to create evidence that doesn't otherwise exist. And what we're talking about here on one hand is very limited claim form information or an affidavit as compared to work history, exposure information, social security records, diagnosing medical, union records, employment records, personnel records. All of that is the other part of what goes to a bankruptcy, but Judge Davidson already requires that very same information be made available to defendants, and that's available to them when they depose the plaintiff. So what they can do in terms of asking the plaintiff the questions is much, much more important than what a one-page affidavit might say, which Judge Davidson has already ruled is not relevant to Texas's causation standard. And that's the part of the bill that no one's mentioning here. Effectively, the bill would undermine Borg-Warner versus Flores, Texas Supreme Court opinion. It would undermine Judge Davidson's application of Borg-Warner versus Flores, which basically says that evidence of bankruptcy claim forms is not going to prove responsible third party. It's not going to give the defendant any meaningful evidence in terms of the ability to allocate fault. For these reasons and those otherwise presented in the paperwork, we do oppose the bill. Happy to answer any questions.
Okay, thanks, Mr. Blevins. Senator Ellis.
Thank you, Mr. Chairman. Is this Judge Davidson from Harris County?
Yes, sir.
Any one of you know whether or not it would be a conflict for Judge Davidson to testify, or maybe I should ask the chair, is Judge Davidson testifying as a resource?
We don't show.
Do you know if it would be a conflict for him to?
He testified in the House Committee last week, happened to be there testifying on another bill, was asked to come forward, provided testimony, and we did provide some excerpts of that testimony in the materials, Senator Ellis.
Just as important of a bill as it is, I think it'd be helpful to hear from, if it's not a conflict, since he did on the House side, to hear from. I mean, it sounds to me, I'm not an expert in the space, but if I'm right, we are talking about somebody who, according to the court, is a wrongdoer. The person has been found negligent. And so this appears to be a way of trying to reduce the pain on somebody that, because of their negligence, inflicted some pain.
Effectively, the bill addresses directly the judge's current case management order and standing orders. It directly affects his ability to hold attorneys responsible for their continuing obligation to supplement and to report. It directly affects his ability to sanction those lawyers. It directs his ability to proceed with cases to trial in an orderly fashion, of which today mesothelioma victims are really the only cases moving forward, and they're going to die within 6 to 18 months.
And I guess I should ask Chairman Upton when she's back. I mean, I know over here, since we don't need but 19 votes, at least I'd like to act like I'm being deliberative. So I think it'd be helpful to hear from the judge, to be honest with you, at some point. Thank you, Mr. Chairman.
Thank you. Ms. Hunker.
My name is